Thank you very much, Honorable Chairman. And let me also join the chorus in congratulating Professor Mensah Bonsu on her nomination to the enviable office of the Supreme Court. I used to get scared of the name because the first day I met her in 1986, it wasn't a friendly meeting. And it led to my expulsion from the law class at Legon. So that's good. I've always admired your firmness. Chairman, I'll ask for some laxity because my first question has to do with a paper, something that is dear to my heart, and I've talked about it for some time. The politics of inclusion and exclusion of traditional authorities in Africa, Chiefs and Justice Administration in Botswana and Ghana. It's written by Setri Jivenu from the University of Edinburgh. And in this, he tried to look at the contribution of traditional authorities to the dispensation of justice in Africa, and especially in countries where chieftaincy is very important. And historically he analyzed the benefits to society. In recent past, one fundamental judgment of the Supreme Court virtually took away the authority of traditional authorities in dispensing justice in our traditional setup, in our communities. I think the case, is it Ajiampofu? I've forgotten the case. Don't you think that this erosion of traditional authority and that recognition of their right to arbiter and also dispense with justice within their community is one of the reasons why we're having this backlog of cases in courts, and also possibly the erosion of our traditional socio-cultural values?
Thank you very much. Yes, it does touch a nerve. At the same time, we have adopted for ourselves a constitution that binds everybody who calls himself or herself Ghanaian. That means that people should have the same rights. Our traditional authorities do very well in their traditional areas. Unfortunately, so many people now live all over that they are not subject to particular traditional authority. How do you deal with that? How do you put people who are subject to a traditional authority under a burden that others are not subject to? The Republic recognized the importance of traditional authority, certainly in dealing with issues that pertain to that institution. That is why there's that track of cause or matter affecting chieftaincy. In domestic matters and so on in the communities, they still hold courts, they still give decisions. But if people do not accept that authority for them to give the decision, and they are citizens with rights of access to the courts, then it's difficult not to see their point. Their authority remains a moral authority. And once we have agreed to live together as a unitary state, subject to the same constitution and so on, the laws cannot be different for different people. So it's a pity, but in the areas where their authority is really accepted, they function. They do customary arbitration. The Arbitration Act recognizes that they can do, the ADR Act recognizes that the customary arbitration conducted a certain way is acceptable. So what we can do is to empower them. It's not every chief who has the distinction as Nana here has. So if we can give some training. I was involved in a program that trained people, religious and traditional authorities around the country on ADR in the beginning when we worked on the concept. So we can empower them to do what they do better so that people will accept. But we cannot let a group of people be subject to disabilities because of where they come from. Everybody should have access to the courts. But we can do, if what they do is done better, people will not even resort to the courts where it takes too long and all of that. Unfortunately, it's a development that we have to accept once you adopt a constitution.
Thank you. And my second question has to do with personal beliefs and principles. In a lot of jurisdictions, at least some of us have had experience of listening to vetting of Supreme Court judges in other jurisdictions, and most of the time, their personal beliefs and principles are also brought to the fore. I know you are as a very strict Methodist, but let me say here that if I'm not going to trouble you too much, can you elucidate on your personal philosophies on question of abortion, the death sentence, adoption, and solicitation, and whether these things would, in a way, influence your decisions as a judge of the Supreme Court?
Can we answer? Sorry?
Ignore their asides and address me.
Yeah. I have personal beliefs, but that is not why I should impose them on you. So, with the death penalty, for example, people talk about why it does not reduce crime, the fallibility of the system, and so on. I came to that position from a completely different angle. I once worked at the prisons doing my national service, and there was a case that we had to investigate, and so I got friendly with one very elderly prison officer. And the way he described, apparently he used to be an executioner, and the remorseless way he described how hanging was done told me that it is a system that dehumanizes those who must implement it. We should not put people in the situation where they get up to go to work in the morning and they are going to kill somebody and hold his neck and push him this way. And I said, this is something that shouldn't happen. So I don't look at it from the other side at all, but from the side of those who must do the execution. It dehumanizes them completely and brutalizes their senses. Abortion. Under the Criminal Offences Act, there are strict circumstances under which abortion is permitted under our law. I have no issues with that. You had some adoption, a very welcome situation for us, so that we can match needy children who need care with adults who want children to care for. Wonderful system for me. I don't have any issues at all. So let me just say that I really don't have any strong views on any of the things you've talked about, except the experience with this old man who was describing to me how you grab the person from behind and you... Solicitation. Generally at common law and so on, what we call commercial sex is not permitted. But it is the only offense where only one party gets handled. The seller is dealt with and the buyer is left off the hook. And I have a problem with that. So if we can make both buyer and seller culpable, then, but generally the idea is that the best things in life are free. So you shouldn't sell some things. But I think it unduly penalizes the female when the powerful male who is ready to buy is not censured.
Chairman, Madam, the next one has to do with your experiences across the world. Possibly you're one of the most experienced persons when it comes to listening to people who have been involved in genocide, in conflict crisis, and all those things. A lot of these were as a result of electoral disputes. What lessons did you learn in some of these areas? And what advice will you give to this country, Ghana, in order not for us to also fall into that river?
Thank you very much. Let me say from the onset that I do not believe that there's anything like a good war or a bad peace. When law and order breaks down, the human being is an animal. The kind of things people do when there's no law to restrain them makes you know that our veneer of civilization is very thin. And we all must guard the legal order, because when law and order breaks down, nobody is safe. That said, I would urge Ghanaians to understand that there's nothing like a good war or a bad peace. Everything that is fought with violence, in the end, is settled by talking. There's never been a peace agreement where the people went and boxed. They always sit, talk the problems through, write commitments, and wave it around that they've signed a peace agreement. If we are going to go there in the long run, what's the point of destroying the little we have in order to get there? So we need our leaders to be mature. We need our leaders to understand that their influence on their followers may take them lengths that they themselves would never contemplate. So we need to appreciate the weight of our words. When I'm teaching complicity, abetment, I always remind or tell the students about this situation in history that formed the plot of the book Murder in the Cathedral. The king and the bishop were in a contest. In history, it's called the investiture contest, as to who had power to invest who and so on. So this king, I think it was Henry II or one of those Henrys, goes on and says, won't someone rid me of this turbulent priest? His knight's head, they rode and went and killed the man in the cathedral. I doubt that when he said, won't somebody rid me of this turbulent priest, he meant that his people should go and kill him. But when your followers are trying to please you, they will anticipate what your every need is and give it. So when you are a leader, you have to remember that there are people for whom your word can mean life or death.
Well, Leland, on the note of life and death, you are done.
Thank you very much, Mr. Chairman. I'd like to congratulate my sister, who is also my room's wife, and I'd like to share the various complimentary words that has been expressed here. And I don't think I'm going to go. I have about 2 questions to ask you. Going through your CV, on page 3, I know that our educational system has been dynamic in a way. I saw in the CV, and the committee served under University of Ghana. There was a committee on preparation for reception of SSS students into the university. I would like you to share with us what actually prompted this kind of committee. Thank you.
Thank you. When the country changed its educational system to adopt the SSS system, moved from O-level and A-level, the university had to ready itself to receive a different crop of students. The O-level, A-level system was 7 years. This was going to be 3 years. And so clearly the university had to be ready to receive students a little less prepared than those who had gone through secondary school for 7 years. So we had to plan what the university needed to do. It is from the work of this committee that the 4-year degree program was developed, so that we could handle this group of students who were not like those we had been handling before.
Thank you. Mr. Chair, I'd like to find out whether you believe in changing some aspect of our educational system. I'm looking at the way we come out. I think the school system is such that everyone is only geared towards certain profession, instead of looking at the technical aspect of our development. We're only looking at certain aspect of education, which we believe must be, I won't say we believe, I want to seek your view on whether there is a critical need, and at what point in the child's development should we determine which direction or which profession a child should pursue. Thank you.
Generally, we have not served technical education well, and that's a price we will continue to pay, because every form of education has its role in the economy. We even set up, those days, we called them polytechnics, and then they were training more art students than technical people. So we need to get our bearings right. We are not going to go anywhere if we don't give attention to technical and vocational education. Some people are of a certain bent. I can't sew to save my life. But some people are earning a living sewing without ever having been formally trained. People have different talents. So we must make it possible for those who have those talents to exploit them and also have a good life. But if the economy doesn't open to allow such people to have a good life, then everybody will go where they think they will have a good life. But if you are not well suited to a certain place, you just won't be able to make a success of it. So we need to give attention to those who have those skills and offer opportunities for them to upgrade their skills, so that I know that, at least I don't know if it's still happening, but people were importing workmen from Togo and so on, because our people don't finish work well when they've laid tiles and things like that. Can we create opportunity for people with those talents to reach the height of that trade and live the kind of life that we would have lived if they were, whatever profession you want to think of. So we need to give attention, definitely, and to encourage those who have those talents to exploit them, instead of trying to be clerks when they would have been fantastic bricklayers.
Thank you very much. Looking at your background and your wealth of experience, I find it very interesting, and I think I must ask this question. If you observe a party in your courtroom with a case but being poorly presented by an unprepared or ineffective lawyer, how would you handle the situation? I'm just looking at your background as a lecturer and now as a judge. Thank you.
At the level of the Supreme Court, there may not be that many situations where that happens. But I've been trying, and I'm glad you asked the question, because when I'm harassing my students to think and to be thorough and to prepare, sometimes they think I'm talking too much. So I'm glad you've asked the question, so they will know that so much hope is imbued in them by the people who hire their services, that you cannot afford to show up and not do a good job for your client. One of the papers I've just written is about counting and being counted on. All that paper is talking about, and this came from a lecture I delivered at the Faculty of Law, University of Cape Coast, that when you are a lawyer, you count for something. So you must be counted on, that you will do a good job, that you will represent the people who have trusted you the right way. So let's just say that I'm trying to avoid the situation you have asked by getting them now to appreciate the importance of doing right and preparing for every assignment.
Thank you very much, Honorable Lecturer.
Thank you, Mr. Chairman. The learned or white. Chair, don't mind those who are harassing you. Be firm in the chair. Congratulations, Professor H. No, the way the papers were presented is H. John. No, H. John Mensah Bonsu. H. John Mensah Bonsu. How do you know him? Congratulations. In the area of peace and conflict resolution, this thesis of your CV is full of experiences, papers you presented on peace. You must be a peaceful woman. But how can we in Ghana get the elements of things that can make the nation peaceful? We already have a National Peace Council. What else should we have in addition to that?
Thank you very much, sir. On the international circuit, sir, you'll be surprised how much our peace architecture gets plaudits, because other people don't have a peace council organized in the way ours is. So we have a lot to be proud of, but we must empower the council to do its work. A lot of the time, we have fine institutions, but sometimes we don't give them the funding for them to do what they have to do. But other people don't have them at all, and they envy us for the council that we have. And the council is doing its best. It has averted all kinds of situations. Because we didn't hear about them, we think they didn't happen. But the council has been doing a lot of work with the little that they are given. So I would say, let us support that peace architecture to be strong so that it can do the work that it has to do. In every society, there are fractious elements. And when people have issues, they must have an opportunity to peaceably resolve them. To not have an opportunity at all is sometimes the reason some things happen. If you have nobody to complain to, nobody who will take up your cause and reach the other side to talk, you can have issues. So I think we have a very good peace architecture, but we must give it what it takes to do the work well.
Mr. Chairman, still on peace. No, not on war. On peace and conflict resolution. Is it not about time for us to introduce courses in our various institutions on the study of peace and conflict resolution?
It is part of what is taught at the Lagos Center for International Affairs and Diplomacy, and also the Department of Political Science. But if by that you mean generally peace education, I couldn't agree with you more that starting from the lowest levels, the NCCE could make a difference there. Because in all the countries that have peacekeeping missions, it is the task of the human rights section to help nurture a culture of peace and respect for human rights. And so they start these clubs in the schools. And the whole point of it is to make them, those ideas, such a part of the growing up of children, that they are more likely to peaceably resolve their conflict than otherwise. So I agree with you that we should start from when they are very young and teach them how to manage their differences without resorting to violence.
The issue of conflict sometimes is also arising out of our differences, either in religion, culture, or otherness. People see each other, oh, these people are like that. These people are like that. Fortunately for us in Ghana, we've been trying to weld ourselves together. But what else more can we do so that we see ourselves more as Ghanaians than say, oh, he is from here, he belongs to this group, and all that. What else from your own experiences all over the world? What do you think we should do to have this country integrated?
Nation building is not an easy task. And welding a variety of groups, heterogeneous community into a whole is also not an easy task, nor does it take a short time. There are some things that put societies at odds. Inequality is one of those. Unequal access to national resources is one of those. Inadequate education and educational infrastructure. So everything we do, we must do it for everybody. Of course, there are challenges because we are not so wealthy and so on. But if we can do these things, and people put a premium on peace, because with peace they have some things, they will not seek to destroy it. But nothing frustrates a society more than when some people can see others enjoying things they can only dream of. Then they don't think they have a stake in the system. And so when they are destroying it, they don't think they are doing anything wrong. So we have to pay attention to all of those things that make it possible for a Ghanaian, however born, wherever born, to aspire to do the same things.
Okay, thank you. I was actually coming to leadership, but no, please, we've had enough. The Honorable Minister has requested for a opinion to congratulate her classmate. That's all I'll give her.
Thank you, Mr. Chairman. Mr. Chairman, I'm not going to ask the nominee a question, but to use this opportunity to congratulate her. She's my classmate from high school, lower six, upper six, all through the 5 years of university. And I'm proud and so happy that today she is definitely, with the endorsement of this House, going to sit in the Supreme Court, the highest court of our land. We've also talked about her accomplishments, that there's no doubt that she's a knowledgeable person, she has experience, and she shares this experience. But she also has a very full life in the sense that we don't know about the social side of her. She likes to interact with people.
Thank you very much.
She has a good relationship with people.
Thank you.
Mr. Chairman, I like to say she will only but enhance the status of the Supreme Court. Live pure, for her. Speak true, right, wrong, follow the king.
Is that the Wiggy song?
Here is Honorable Leader.
Thank you, Mr. Chairman. Mr. Chairman, I take the opportunity to congratulate the nominee and to say I wanted to look at her CV. I don't know whether it's by her. Page 2 of the CV. On the employment history, she said University of Ghana, July 2018 to October 2017. 2007. As what? The mic, please. Sorry.
I apologize. I had to break my service in the University of Ghana into two so that the UN one would find a place. So I should have indicated that as a lecturer to professor.
Okay. And you see that it follows with the UN, United Nations Organization, November 2007 to October 2011. That you didn't tell us what you were doing there. And then virtually similar to the following one, University of Ghana, November 2011 to July 2018. So maybe you could just...
Actually, she has explained all that when she was giving us that.
I just want to find out, did you retire July 2018?
Yes, honorable member. In the University of Ghana, in order not to disrupt the academic year, we all retire on 31st July. So those of us born after 31st July of a particular year get to serve till the following 31st July. You would agree that if I had to leave the lecture room on 29th October 2017, some students would have been in trouble.
I just want to find out the legality of that. Because they just followed by giving you contract just the following month, which meant that they could have gotten you to retire on the right date and just make sure that 3, 4, 5 months before you retire, they prepare to give you the contract. Because legally, you are supposed to retire at age 60. And everywhere in the public service, 3-4 months before you retire, they write to you to draw your attention that your date of retirement is due. You think that that is not problematic?
That is correct, but even the Constitution anticipates that judges can't just walk off the job even when they are retiring. That's why they give them some 6 months to finish their part heads. In an educational institution, it will be unduly disruptive.
No, what I'm saying is that in your case, because they knew they were going to give you a contract, if you were just retiring to leave, that would be different. But because you are going to be on contract and they knew, and I don't think that it was after you retired that they anticipated that they were going to give you a contract. Yeah, so once they knew that, they should have just allowed you to retire and then they give you the contract to continue.
Sorry, it's not special to me.
I know.
That is what...
that's why I was asking you whether you thought that the arrangement that the universities have it falls on the face of the law.
There are all kinds of categories of staff, and I'm sure that the Constitution means well by fixing that retirement date, and we all agree. But the problem is if you implemented that, there would be total confusion, and I don't think the university would bless that, because there are all kinds of categories of staff. It's not just teaching staff, and it's only a category that gets the contract. So it's not everybody who gets the contract.
Well, I have argued, and Chairman will argue a number of times around this table and in our private discussions. I have insisted that if there's one category that we need to relook at to amend the Constitution, is the lecturers, because the older, the better. So maybe use the yardstick of fitness to practice as a yardstick instead of just using the age, because sometimes, yes, they may be old, but they'll be very useful. Just to move on page 7 of your CV, I noticed that member, academic board of the university, 1997 to present. Even on retirement, do they allow you to serve on this leadership role at the university? Because I know that it is only the teaching, but do they allow you to continue on such a board?
All professors are members of the academic board. So when you are given the post-retirement contract, it's on appointment as professor. So
you continue?
Yes.
Oh, okay.
To say continue is because I had an issue with them. I now am, but I was the assessor for humanities. And when I retired and got the post-retirement contract, they assumed that it would continue. And I said, no, I have to be appointed afresh. I was a representative of the academic board on the Appointments and Promotions Committee. And I said, no, I have to be appointed by the academic board again because I retired. And they did that, and I'm back doing that work. So, yes, it wasn't continuing. It was a fresh mandate, yes.
So that means, from what you are saying, that means the description here should have also been broken down. From 1997 to date.
Yes, because I became a professor in 97.
And that's what I'm saying. From what you have just explained, after you retire, you insisted that they have to reappoint you.
Not to academic board, but as assessor of humanities.
Oh, okay.
We have assessors for humanities, assessors for sciences, and we have to be part of every appointment and promotions committee. So, and I was representing academic board. And so they thought that, well, I was still around, and I said, no, I'm in a different category. When you become professor, you attain tenure. Before you are a professor, you are on contract. So every 6 years it's renewed. When you become professor, there's no renewal. When you retire, you are appointed on contract, this time on 2 yearly contracts. It's a different category altogether.
Okay, understood. From your seat, I noticed that you've done a lot on reproductive health. Is that right? So I want to believe that you are very familiar with the Children's Act. I have argued, even on the floor of Parliament, that the right for a child to have sex at 16 years, whilst the right of that child, of a girl or a boy to get married 18, for me, was problematic. Having worked all these years in this area, will you agree with me, or you think there's some special reason why we think that the children are 16, they can have sex without necessarily, they can consent to sex. But for them to get married, they have to be 18. Do you agree, or do you think there's some special reason why this arrangement is done?
Indeed, I agree with you, and I have pointed that out in my writings. At the same time, there is the problem of, if you raise the age too high, then in a situation where you are trying to even fight child marriages and you are not being successful, it would be self-defeating. At the same time, to keep the age low and to keep the age of marriage at 18 does create this gap where, as you say, the child can have sex but cannot marry. But maybe that is a consequence that is better for us than making the age of marriage 16 years, which would be violating all kinds of international commitments that we have made. So not everything can be neat and tidy, but we live with it.
This is where I make reference to your earlier answer to a question, where you said when you want to look at your culture in the eyes of some other persons, you may get something else. Guess here, because I mean, almost all of us, from Binduri to Accra here, from the west to the east, almost all the cultures, regardless of religion, frown on premarital sex. Now we have a law that, because we want to meet an international obligation, we say the children can have sex for almost 2 years before they get married, or they can consent to sex before they can get married. And Madam, you and I have chaired the health committee, and when you talk to a lot of Guyanese, they tell you the kind of pregnancy and the challenges that come with all that. Don't you think that it is time for us to stick to our law? If we think that the best time for children to be able to do that is 18, let the marriage and the consent to sex be synchronized.
Honorable, I would have loved to agree with you, but we also have to be realistic. Policing it would be impossible. And you are saying that the girl cannot consent to sex until she's 18, which means any sexual contact would be criminal. That would also have its own repercussions. So, as I said, it's not neat and tidy, but you don't want to let 16-year-olds marry, nor can you police that they should only have sex when they are 18.
Anyway, let me move on. The interstate succession law, and I can realize that you've done some work on that, and the law, if my memory serves me right, since I came to this house over a decade and a half, have been to this house severally and failed. In my view, because the emphasis of the bill tends to be on spouse. And I've said it very loudly when we're looking at the principle of at one time, that for me, I'm the biggest insurance for my mother. And if you take me away, and probably with my siblings, and depend and take everything that we have to our spouse, our mother will have to beg. But she has spent all her life to bring us up. And yet, when we are making this kind of laws, we tend to forget parents. Because if it is spouse, if for any reason it is my wife who passes on and leaves me, or me leave her, depending on the age, they may be able to cope with either getting new married or continue to work. But today, my mother, who is alive, is weak, and I'm her only insurance. I am of the view that, well, if we want this thing to pass from Parliament easy, we need to look at that composition about parent. And secondly, children. Because even in what we brought, the emphasis, like I said, is on spouse and not even on children. Children could be younger. And we know if the spouse is the female that lives to leave the male, he could go and marry another woman and forget about the children. The same with women. Sometimes, yes, the propensity rests more on men likely to carry away and leave the children. Do you agree with me, especially with parents and emphasis on children, or at least with one of them?
Honorable Member, I understand where you are coming from. But the intestate succession law, with all its faults, is a default position. If you don't agree with the provisions, then you make a will. With testamentary provisions from you, those will be respected. Because this happens, this kicks in when you do not make arrangements, when you die intestate. So if you die testate, you can solve the problem your way. So what you are saying, I can understand. Take steps to protect your mother under a will. And that solves it, because there are all manner of situations also where without an intestate succession law, there would be great hardship. It has many faults. I've written about them on many occasions, but it is better than nothing. So take steps to make a will. I always tell people, in fact, that making a will is a responsible act, because you know that once you've been born, you will die. Well, when you are traveling, Honorable Member, when you are traveling from Asawasi to Accra, I don't know where the family is based, you tell them what to eat, you tell them who to go to when there's need for money so that you can reimburse. You give them all these instructions. When you are going away forever, then you just go. And leave the state. And leave the state, which doesn't know your domestic arrangements and your domestic pressures, to make arrangements. The arrangements would be unsuitable to your particular lifestyle. So my advice is, write a will. Then you can dictate what your circumstances should provide for when you are no longer around.
For us, I agree with you. Yes, the best way is to make a will. That's why I'm saying that when we now anticipate to promulgate the intestates law, our emphasis is where my problem is. Because yes, ideally, to make a will is the best. Many times the tendency is that, I believe that I'm still giving birth to children, but if I make a will and before the next will another child comes, I don't go to update my will, what happens to that child? And all those things, I know, but if, like you said, each time you are traveling, you try to leave somebody to watch your back. But my worry is that when we are making the institutes law, why are we not proportioning the emphasis in a way that holds the society? Because I can bet you, it is the reason why it has failed consistently each time it's brought to the House. Because anytime we go to clause 4, we will argue for 1 week, and then the Speaker realizes that if he doesn't put the bill aside and pick another business, then the bill will hold the House for the rest of the sitting. So, okay, can we pick another bill and come back to it? And we never come back to it. And my memory tells me that we'll come to this about 2 or 3 occasions, about 3 parliaments. We just do that, and then it fizzles out. Why are we not going to be realistic and look at having something that is half a loaf, in my view, is better than having nothing or just keeping the current arrangement as it is? What is your take on that? Honorable Member, I am glad you more than me can do something about the situation. So if it is an unsuitable position, then you can change it.
If it were that simple, we would have changed it.
Yes, it's not. And I'm just saying that please understand that it is the default position. if you make arrangements, nobody is going to come from outside and sort your household. Your mother is alive and you need to look after her. I agree. I also have an article on maintenance because I think it is inequitable that parents are held responsible for not maintaining their infant children, but adult children are not held responsible for not maintaining their elderly parents. So I understand where you are coming from, but we cannot use your special circumstance. My brothers are here. Our mother is dead, so that's to do anything with your property.
Thank you. In my case, maybe the will will just be a one sentence. When I die, distribute in accordance with the Mohammedans, and that's it. It will not even be up to half a page. It will just be a one line, and then that's it. Anyway, Mr. Chairman, the nominee as a law lecturer and academic of great repute who has written extensively on legal matters, how does she assess the current state of legal reasoning in our court? Legal reasoning in our courts.
Honorable member, is this an offside trap?
My Lord, I want to ask him to clarify or zoom in on a specific area, because ask him to pass a judgment on colleagues is going to join.
Oh, no. I'm not talking about this. I'm not even talking about Supreme Court here. I'm talking about the legal. Yesterday, like I was reading, I didn't want to keep us for long. You have court yesterday, one of the justices agreed with me, saying, they say, oh, I've looked at your case, it's unmeritorious, and therefore the case is dismissed.
Okay,
without even giving
the judgment.
Yeah, I'm talking about, yes.
Right. Some write the judgment, just the verdict without the reason. That's what
yes.
I'm referring to.
I believe that's why there's the Judicial Training Institute, because in the past we assumed that everybody who had gone through a certain training could do certain things. But experience has shown us that you can always do better whatever you have to do with more capacity building. And so the Judicial Training Institute certainly makes it possible for such infractions, in my opinion, because if the person is going on appeal, what's the person going to appeal against? So the Judicial Training Institute should be able to do something about that to help it so that it doesn't happen.
A lawyer since 1982, right? For your CV says so. Is there any judge or judges that you believe their judicial approach and attitude to adjudication you admire and consider to be fair and balanced? You admire.
Honorable member, I think that every case dictates how it is handled. So it will be difficult for me to answer the question. Sometimes the most conservative judge in some aspect becomes the most revolutionary in other aspects. So it's difficult to pass a judgment.
That was why I was asking for maybe a judge or two, because I believe that over this period of over 3 decades of your interactions with court, students, reading cases, maybe there's somebody that you may want to mention, or you don't want to. You don't want someone to say that, oh, when you were mentioning, you left me.
Thank you very much for understanding, sir.
That's my last question.
In the academics all this period, and I mean, your CV speaks a lot of how extensive you've been. I mean, very detailed, and I must also admit, in the Ayawaso Commission, initially when you were mentioning, I was a bit skeptical, knowing from the
reconciliation committee. But I must admit, you proved many of us wrong. You were very strong. I mean, you spoke your mind. You were very forceful. You believe that these years of academic research and academic work has prepared you enough for the Supreme Court?
Thank you very much. Thank you very much, sir. Part of what it takes to write is to critique judgments and teach students what to look out for and what shouldn't have happened and all of those things. When you've done these for years and years and years, then perhaps it's a situation of physician, heal thyself. So I would say that having critiqued enough judgments, perhaps it's time to offer myself for critiquing also.
Mr. Chairman, thank you very much, and I wish you well.
Very well, Honorable.
Chairman.
No, okay.
Honorable, I would brief as possible and to ensure that my closing comments are as short as an old woman's dance. Prof, university lecturer, exiting now to Supreme Court. I know, Chairman, and I'm sensitive to it, as you observe, that the Chief Justice, Nana SKB, and Professor Raymond Atugu have all been sitting for long hours. We don't intend to keep you further more. But university, would you want us to adjust the retirement age, given your experience, from 60 to 65, or to where you are heading towards at 70? What's your view on that? At 70, what's your view on that?
The university did find a way around this problem by offering 2 yearly contracts for those who made the professorate, so that every 2 years, they know also that at this time of your life, your health is not what it used to be. So every 2 years, subject to good health, they would renew the contract till you are 70. That was the position until a year or two ago when the Auditor General complained. And so from 65, you can still be kept but as a part-time lecturer. But the part-time rates are so atrocious that the private universities are very happy to take your people and pay them better. So we are hemorrhaging, so to speak, of the people who have attained 65. So definitely, I would say that if we can at least get back to where we were.
Where were we? Or
every 2 years, subject to good health, you get a contract when you make the profession.
No, but contract and just making it a permanent part of your life. Which one would you opt for?
I didn't want to be overambitious.
65 years. The lawmakers are here. Your students
But of course, if we are going to change it, then I would say the 70 would be fine, because once you attain 60, you lose your tenure. And you become subject to the 2 yearly contracts. Every 2 years, you have to prove, my dean is here, so I'm not going to say too much, but every 2 years, you have to prove that you have done enough work and you are healthy to be carried on. When,
Chairman, thank you.
Many years ago, you'd stop.
Prof, do you serve on the National Development Planning Commission?
Yes, I do, sir.
Do you intend to combine that with your high office of Justice of the Supreme Court?
Not at all, sir. Some things are going to have to change.
Should we expect naturally that you'll be quitting or resigning from that office?
Oh, absolutely, sir.
And Chairman, I have learned 2 lessons from the professor who undoubtedly have contributed, as I've said, from her reading to particularly our criminal jurisprudence. If you've read the Criminal Procedure Act in particular, you have enormous respect for her. Bailable and non-bailable offenses. As you sat home and the Supreme Court took a decision on it, how did you feel?
Let's say that I was thrilled that my article on bail was cited in that case. I thought it was Section 96 had been inserted during a non-constitutional era, when the value of the human being was not like under a constitutional era. And I thought it was inequitable that it should remain on the books. So I am thrilled that the courts now have the discretion to do what they have to do. So in my article, I insisted that the right to bail is actually a right of the judge. Because
thank you, that's appreciated, Chairman. Chairman, I've learned another lesson from the nominee. Maturity with our words, including political office holders like me, and then settling peacefully from events that emanate violently. But when you were expatiating your thought on solicitation and the buyer and the seller of a woman and a man, buyer and a seller, those are my words. Chairman, it led me to corruption. Part of our difficulty as a country in dealing with it as a criminal offense, as I've read from you and many others, is that it's the only crime where the two parties benefit from the commission of the act. That makes it difficult. So is that like the buyer-seller in this instance, where one profits from the exploitation of another and then turns around to say that there is no adequacy or adequacy of compensation? Now, how do we make corruption a high-risk activity in Ghana?
Thank you very much. The category of crimes you mentioned in the criminal laws are described as victimless offenses. But are they really victimless? I think that we need a proper code so that we can, you keep hearing cultural arguments and so on, but we can have a code that defines what amounts to corruption. Currently, everything amounts to corruption, including if you are unable to manage your weight and you start gaining weight, they say,
That's noted.
So I think, so I think you'll be surprised how many people. I once chaired a committee of inquiry when I was at the prisons, and the people had diverted some essential commodities. Those of you who remember those times, and so a committee was set, and I was the chair. A witness who appeared insisted that before he had incontrovertible evidence of corruption, because before that person joined that panel, he couldn't even afford a full proper meal. Now he eats yam and sardine. So we need a code so that there's an agreed standard.
So
in the UN,
could only remind you of the 1979 era of Ghana.
Yeah. In the UN, when you are given a gift and it is more than $250, you have to turn it into the Secretary General. You cannot accept a gift that is higher in value than. So in the end, the things you get are these little things. Nobody has a problem with it. But here, we don't regulate. And it's a problem. So we need a proper code. Then we need an office. The UN has an ethics office. So when I joined the UN and I declared my assets, and including anybody that you are a member of its directing council or whatever. At the time, I was a director of Stanchart, and I was asked why I wanted to remain a director of Stanchart. And I said, oh, there's no, that bank is not in this country. They said, no, whatever it is, you cannot hold it. So I had to resign.
Chairman, thank you very much. Just one more on Ayawasu Wagon and your observation as it became a significant blur on the conscience of our democratic practice. Yes, over time, we've had party activists be at each other, but not when you have state security agencies engage in excesses. Now, whilst answering the Honorable Ablakwe's question, provocation, is it a defense to criminal assault?
That's why I offered to give lectures.
So that those who don't know will learn from you as I'll learn from you.
Yes, under our law, it is only available when death has happened.
So if you were to situate the government white paper to the provisions of Article 296, will it satisfy the minimum test under it? A government white paper, exercise of discretion. Was that discretion in tandem with the provisions of Article 296 of the Constitution?
I wouldn't raise an error of law to the stature of a breach of constitutional discretion. I think really we are talking apples and oranges. Definitely it was an error of law, but I don't think it is a matter of constitutional discretion. No, I wouldn't go that far.
Thank you very much, Chairman. Chairman, my conclusion, it's my last. I'll keep to the way. It's just an observation. While serving as young minister, I'm sure I was then at Ministry of Trade, and this question has to do with your role at Lesia and probably what we all commonly can help strengthen and improve in pursuit of foreign relations. I wrote to a mission abroad as a minister, and this is my concept of foreign service official as a diligent officer for the state of Ghana. And I was dealing with a U.S. company we needed to do some engagements in Ghana. I believe it was Bloomberg Grains. Then I write to a foreign service, the foreign mission in the United States to guide me as minister before I took a decision in due diligence. I find a letter coming from our foreign embassy giving me all clear that I could proceed with the transaction. Then 48 hours, I get a signal from the U.S. Embassy in Ghana to be cautious going forward with it. That meant that in the training of our foreign service officials, minister, he is not in the U.S. He doesn't know a particular company comes. You expect the foreign service official to provide you diligent basis. Then they give you a letter that all is well, when in fact, by the U.S. system here, they found something fundamentally wrong. Do you think the training of our men and women at Lesia will need to take advantage of circumstances of this nature?
Thank you very much. Yes, we expose them to all manner of, all aspects of diplomacy. But you would also agree that the situation you discuss, it's a specialized situation. So maybe the person you asked was not somebody who knew much about rogue companies, for example, and so took it at face value. Oh, that's the office, nice building. And I went there and they received me nicely. So they are a respectable company. When the person should perhaps have checked records and things like that. So I would say good in-service training would be helpful. And then we should start getting more specialized, even in service, because the world is moving towards specializations. Not everybody can know everything into the detail that they must. So I would say, yes, we can do better, but at the level at which we get them to train, perhaps they might not be in the position to offer the kind of advice that a minister requires. But if I may ask, did you write through the foreign minister or you wrote directly to this person?
To the foreign minister and to the Ghana mission abroad, not to any individual person, but the correspondence which came did not, in my view, conduct a thorough diligence. So in training our foreign service officials, I just thought it should be an observation. But without wanting to keep you further, Chairman, is to congratulate the nominee, as I've observed, except that I've borrowed her words, invasive and intrusive. If we find EI 63 invasive and intrusive compared to Article 18 of the 1992 Constitution, which protects privacy of communication, and Ghanaian citizens, whether dealing with MTN, Airtel, Vodafone, or any service provider, does not feel secured with the protection of their data, that conflict, what will be your advice dealing with it? And on that note, I thank you and I wish you well.
Mr. Chairman, we have allowed all kinds of technologies into our lives that have breached our walls of privacy. Google Map can show you a picture of your house. You can see the picture, but so can miscreants. And yet we have all bought phones that already has that app on it, and we use it happily to find our way around traffic in Accra. I'm saying times have changed, things are changing. So when there's a public health emergency that requires us to be intrusive, then we should restrain ourselves from doing what is not necessary. And that's why I was saying proportionality and the doctrine of necessity should be our guide. But we are all terrified, so.
Very well. On that note, I want to ask a question on governance of the digital world, social media. Should users of social media be subjected to all the laws or rules of the ordinary publications as operates in the print and other electronic media?
Mr. Chairman, I think so. Mutatis mutandis. I think so. Because now you will not have somebody hijack you with a gun on the highway to take your money. But you will have somebody hacking into your account and taking your money, all the same. So life has changed, things have changed, and we must change accordingly, because otherwise we have a problem. For instance, social media has undermined one of the most fundamental assumptions that we were trained with. I'm sure all of you have heard the expression, book no lie. So whatever we saw in writing, it was the truth, because there was gatekeeping in print media. Now everybody is a citizen journalist. So there's no gatekeeping anymore. So you can't even trust what you see on social media. The young people always tease us, the BBCs, that we are the worst offenders of forwarding fake news. Because we were trained in a system where when you received something in that way, it was true. It's a different world where people can do creative writing and start passing it on as non-fiction. So yes, those rules must apply.
The last one, I'm not sure whether I want it as a question or a comment. Taking care of babies, why should it be the responsibility of the woman and not both parents? I want to contrast that. In our everyday parlance, growing up as a young man, I knew that paying for cost for all kinds at home was that of the man. At least in my home, my father was responsible for every cost. And that's what I do now. So why should I also be responsible for taking care of babies?
Well, you see, your father contributed the money and your mother contributed her labor. And together they had a product. So if your wife is also contributing money, then you also have to share the labor. But it has personal benefits for you as a father, that you have such a direct relationship with your children, that it's the blessing in old age. Otherwise, you'll be one of those fathers who can't carry a conversation with a child. And when you are old and your father invites you, come, let's chat. You sit at the edge of the chair. And with the slightest distraction, you are off. But you can sit with your mother all day. So it's a price they pay for not being involved.
Well, it's the part about responsibility. If I could provide money and you take care, we are both responsible. Right. So long as we accept that, I'm okay with that. But, you know, I think that has gone into the interpretation my lords have given to Article 22. Sometimes I wonder whether they are making law or... I would like to read Article 22.3 in particular. With the view to achieving the full realization of the rights referred to in Clause 2 of this article, spouses shall have equal access to property jointly acquired during marriage. Assets which are jointly acquired during marriage shall be distributed equitably between spouses upon dissolution of the marriage. Jointly. There appears to be some interpretation of jointly to mean that once you are married, property acquired is jointly acquired. That it appears that marriage itself is a contribution per se. No, she's not in a hurry to answer me. She's suggesting that you're in a hurry to answer me. Yes. Now, the reading of Article 22.2, does it suggest that marriage per se is a contribution to acquisition of property?
There's the assumption, Chairman, that once you are in a marital relationship and you are doing everything together, everything you own is to... Haven't you been in at a wedding service where the man is saying, I'll share all my worldly goods with you?
No, I haven't been to one. At least I did. Well, we thank you for attending upon the committee. We know that we'll get the opportunity to do what we have to do as a house, so that we take away the intrusion you are bringing into the law. But before I discharge you, let me recognize Mr. Mensah Bonsu of yes, Nana SKB Asante. Yes, he's also a professor of law. Dr. Mrs. Nana Ekwian Kumasari. Right. Dr. Richard Bamful. Professor Raymond Atubiga. Okay, Atuguba. Right, the Dean. Okay. Mr. Alex Bamful. Nana Ofori Bamful. Okay. Mr. Samuel Mills, Professor Justice E.N.A. Kote, okay. Mr. Albert Essien, Mrs. Ya Bami, oh, right. Okay, I saw, my Lord, the Chief Justice has been recognized earlier. I don't know, but I think I saw Christine, yes. Mrs. Christine Dewoda Hammond. Yeah, you're there. Yes, okay. If I refuse to recognize her, I would have done my class a great disservice. And the host of other judicial service and members of the judiciary. We thank you all for coming to assist the nominee. Mrs. Mensah Bonsu, who? Oh, okay. And all members of the academia who came to support her. We thank all of you for coming. Mrs. Mensah Bonsu, we thank you for attending upon the House. We will get back to you. Thank you very much. You're discharged.
Thank you very much, Mr. Chairman, and thank you to the honorable members.